account and let them know that's what you're doing.
Like I said, I'm unfamiliar with that. I can just show you guys what I've done.
Yeah, absolutely.
But I want to hear from everybody for sure, and we can all learn and build together. Stronger together as a community here. So here's the masterclass. If you guys stay till the end, it's not going to be very long. It's pretty simple, and I'll break it down very clear. But if you stay till the end, you guys get all the templates that we've used to discharge this loan, and I'll send you the recording. So we'll jump right in. And obviously, everyone has to give out the disclaimer. This is not legal advice. Like I said, I can only educate and entertain you guys on my personal experience, my personal results. Cool. So I haven't ever really met any of you guys or talked to you guys before, but I've been in the space for about 2 years, strictly banking and finance. Personally perfected my credit report, deleted all negative accounts from that pursuant to the GLBA. If anyone has questions on how we can do that, feel free to message me. But I highly recommend everyone that has stuff that they want removed from their credit report to research the GLBA, the Graham-Leach-Briley Act. Also, class today, we discharged the government SBA loan. At the time, it was like $375,000 upon discharge. I personally just bought a house. Stone personally just bought 40 acres of land, and he can talk about that a bit. Stone also just won a discharge case against Capital One. Stone has also reacquired 4 car titles and discharged 4 cars. And currently, I'm in the process of discharging my home, getting my land patent. Once I successfully do that, I'll share it with you guys. And I'm working with another client who is in current litigation with Amex. So they're coming after him for about $60,000 of credit card debt, and we're attempting to get that case dismissed. And full faith, we're going to win that case, and I'll bring it back to the pack here and show you guys how we did it. But Stone, you want to talk about anything that you've done, or does anyone have any questions?
You bought a house conventionally, or did you buy it through a process?
Conventional.
Cool.
Yep.
And the same with the 40 acres?
Stone?
Yes, same deal for me. I mean, I will say, so on the car thing, and no like disrespect or shade towards anybody, but I've tried like the rescission method like several times, and I'm like 0 for 7 with the rescission method. I don't know. Has anybody had any success using rescission with getting the car title?
The problem with rescission is the law says a signature can't be rescinded if a security has been created. And so like the house that we were closing on and they just killed the closing, I rescinded all my signatures on that and told them that they need to make available the property and the funds that they took. And so the rescission of signature, they sent me a letter back with some like the lawyer said the law that you can't rescind a signature once the security is created. So even prior to us closing on the house, they created a security and obtained the funds for it. So I just got to take them to court to get that or find another way. But yeah, once the security is created, the signatures aren't rescindable.
Even if it's fraud?
Go ahead.
If it's fraud?
Fraud.
Well, so the innocent holder in due course has an effect on the security, right? So because he's an innocent holder in due course, he's not liable for any fraud. So what they do is they create the security, they transfer the contract into a trust or a depositor, and then the company's liable, but the innocent holder in due course is not. So your signature can't be rescinded off the contract because of the security, but you can come against the company for the fraud.
100%.
And I think that's why the rescission's not working.
100%. Yeah, we've also tried stuff like to pay bills with coupons. Honestly, have not had luck.
Actually, I just in January 13th, I walked into the lot and got a brand new GMC, a 2022 GMC SLT. Brand new, 6 miles. I drove it off the lot. I signed all the contracts. You know, as soon as the statement came in, I sent a negotiable instrument to the bank. They accepted it. They sent me title, release of lien, and that was in February. On March 6th, they reversed it when they opened the account. So now there's an account showing with I owe $58,000, but I have title and a release of lien, you know? So I've been battling since March with Capital One on the truck, right? And I've sent them payoffs. They've accepted them, cleared the account, sent me another release of lien, saying we haven't put a lien on your title, so we'll let the appropriate deals know. Anyway, so I've been battling with months for them. So recently, I just sent a statement and a coupon to the IRS with a $74,000 NI. And then that was the May statement. In the June statement, I stamped and did a reversion statement on the statement. And I sent it to them. They accepted it and posted it to the account. And then 2 weeks later, reversed it again. But they reversed it in a way where they're saying they're going to refund my money. It's called a standard allocation payment reversal, which means they're going to send the money back to me. And I doubt they'll send it back to me, but they're acting like they're going to give me refunds, but they're not. Anyway, sorry to interrupt.
Yeah,
No, I've had very similar experiences in regards to coupons with credit cards and also just statements for vehicles.
Real
Yeah.
quick, I want to say there are multiple people who are not muted, and there is noise coming through the background. So please, if you're not speaking, mute yourself.
Thank you for telling me. I just muted everyone. If you want to talk, just unmute. But I'm going to keep going. Appreciate everyone jumping in to kind of give your personal experience. Like I said, this is what we've done. Faith and debit. Feel free to talk to Stone after the class on that. I'm unfamiliar. I've never done that, but I'll be showing you guys what I've done. So a big question that I get from you guys is, do I need to correct my status to do this? What is a status correction? And that whole nine. Status correction is a buzzword that we hear a lot in the community. And to me, in my experience, status correction is just really filing evidence on public record, showing the public, showing other people, other corporations, who we are and how they're going to deal with us in commerce, in business. Since it's public record, it's enforceable. An example of that may be a schedule of fees, an injunction, where we're basically saying like, hey, we're a living man. We have the right to travel. We don't need a driver's license since it's a right, not a privilege. And by filing that on public record, it's now what we say performance contract. And we put basically every public official on notice, telling them our rights and telling them if they pull us over, there's going to be a schedule of fees and they're going to owe us money for violating our rights. So that's kind of what status correction is to me. Putting further evidence of really anything on public record to show other people who you are and how you conduct yourself in commerce. That's what I think status correction is from my experience. A lot of people may hear like the birth certificate here, like authenticate the birth certificate. I did this, let's say a year ago, and it really hasn't done anything for me since. So forget all that, but that's what status correction is to me. Just putting stuff on notice, giving people proper notice on how you are going to operate in commerce. And like I said here, and I told to some of you guys, everything that I'm doing is strictly banking and finance. I don't mess around with any sovereign citizen movement, any sovereign paperwork. Whether or not it works or not, I don't have experience, don't have firsthand knowledge. I do though know that everything is banking, securities, finance, and credit, really. So that's what I'm studying, and that's what I'm going to show you guys today, banking and finance. So a quick overview. I just want to kind of give you guys some clarity on like court, on how kind of this whole thing's work, how this whole thing works. I know everyone's at different stages, but really an overview of court, because I know people are scared to go to court. They don't know if they have to show up to court. They're worried about losing their home. Really, there's one way to get to court, and that is a dispute between two or more parties. Also, you must have a claim upon which relief can be granted against the opposing party to proceed in the case. Failure to state a claim will get a case dismissed immediately. And what you guys may see in court a lot of times is there's really just complaints. You'll have a complaint against you with no claim, no evidence of an injury or an injured party, and really no evidence of loss. They'll just give you a complaint, say, hey, you owe money. We sent you credit card statements to prove the money's real, whatever. And that's what they'll complain to the court for the relief. They'll submit the complaint, but usually there's either no injured party or no evidence of an actual loss on their bookkeeping, on their DOME accounting records. And that can either be a financial, mental, emotional, physical loss, etc. And real evidence showing loss is through a certificate of finance statement, something signed under penalty of perjury showing loss, or an IRS form like a 1047. A few different IRS forms are loss claim forms, where these companies, if you cause them a loss, they're going to be filling out these IRS forms showing their loss in their IRS bookkeeping. It's the DOME double entry bookkeeping. So like I said, most court cases are just complaints, no evidence usually, no injured party. And what we're going to be doing through the administrative process here is asking these companies if they have a claim against us, because that is the only way we can get to court. We cannot get to court if there's no dispute and there's no case. The case is going to get dismissed if they don't have a claim against us. So we're going to start asking these people, hey, do you have a claim against me? Did I cause you loss? Did I cause you injury? Can you prove it? And we're just going to ask them, and then we'll see what happens and go from there. But I'll continue to break this down. Did anyone have any questions on this? It was just a quick overview. Cool. Feel free to drop your questions in the chat too, and we'll circle back at the end. So an overview of court, and we'll keep going. A couple myths. Like I said, a lot of people think like the birth certificate has this unlimited credit. There's an unlimited trust account, and that's just not the case. The case is that us as the living men and women dealing with these corporations, our signature and our endorsement on that instrument, on that application, is what securitizes that note, and they take that and get the money out of thin air. So that's really where you hear like, oh, our birth certificate holds money. That's where we have unlimited credit. But really, it's our signature, our endorsement is what creates the money. Also a myth, banks don't loan money. Banks will never loan money from their own accounts. The money is created out of thin air when you sign that promissory note, when it becomes securitized. That money poofs out of thin air, and that's kind of how the system works. And that makes it a lot easier when we come back and we ask them for evidence of loss, because they know that they didn't go into their pocket and hand you money. They literally got the money out of thin air and then gave it to you. So they're really never able to produce evidence of a loss. And I'll be giving some examples here too. Credit is mess. Should I fix that first or administrative process? So it depends, Lisa. Obviously, you need to have a good credit score to acquire things. But once you have things, then you need to do an administrative process to discharge it. So it really depends on your current situation and where you're at. Yeah, that's key. Good credit is key. You can get anything with good credit. Anything.
Okay.
100%.
Good, thank you.
For sure. Feel free, yeah, guys, drop your questions in the chat and we'll cover all that. But here's a quick example for all you guys. Like, let's say we're going to go buy a car, right? We're pulling up to the dealership. We find a nice car we want. Let's say it's a i8, or it's only, for my example, it's a $50,000 car, and we're at the signing table, basically agreeing, we're signing the promissory note, agreeing to pay back the $50K, let's say over 30 years. The dealer, most of the time, will pocket your down payment if they force you to give a down payment, which down payments are fraudulent. They shouldn't be required. However, most of the time, they just pocket the down payment, and then they take that note, that promissory note that you just endorsed and securitized, and they'll sell it to a bank or a financial institution, and they get paid right away. No dealership is waiting 30 years to get your 50K. They take that, they give it to someone else, and they get paid right away. They then take that money and they invest it to make more money. So they're getting paid upfront and they're using that money to make more money. It's the same with financial institutions and banks. They bundle these securities together and then start trading them on financial markets. So really what happens here is through the usury and through the interest gained over time, they're able to keep selling our securities over and over again, keep making profit. And for us, the natural man here at the end, it's really our energy that has to kind of slave away and give to these companies to pay it back when it originally came from us. So I like to think like everything is just exchange of securities. Everything is securities, whether it be the fiat, the bonds, trading stocks or options, notes, promissory notes, they're all securities. So when you guys are studying this stuff, stay more on the side of banking, securities, exchange of securities. Think the SEC and the FTC. Don't go near that sovereign citizen stuff. Stay on the side of real studying different jurisdictions and really just finance. So
Someone is not muted.
who is that?
Josh,
Go ahead.
I want to just quickly piggyback off what you said. So boom, when I got my Benz, it was $100,000. The finance manager, they paid to fly me out. They paid to pick me up. They served me food and everything. But you telling me I got a down payment. Now I got good credit. That's why y'all paying for all this shit. So I get there. He's like, your down payment, I think it's $5,000. I said, well, I'll put it on my American Express. He said, well, no, it needs to be cash. So of course I know better. So I took money order. So the whole transaction was done. They even paid to ship it to my house for free, a whole nother state away, like state away. He said, you got my down payment? I used to work for a car dealership. So I said, yeah, I got it. I poured out the money orders. He said, no, I said cash. He said, because that's traceable. I said, correct. The trust needs to trace its assets. He said, that's my money. I don't need to be traceable. You can keep it. Just know you owe me a favor. And the second thing I wanted to say, you're right about the securities. We just got an audit done for a car transaction. It shows everything. Bloomberg terminal, everything. It blew my mind. That's all.
100%. I think I've never personally done it, but I think through Dun & Bradstreet, you can audit these companies and the specific account and the security of the account and see kind of like what it's trading at currently.
Yeah, we paid a forensic auditor to do it.
Cool. Sweet.
Yeah, and Dun & Bradstreet doesn't let you either. You have to have like an account in so many businesses.
Yeah, if anyone's personally done it, I'd love to hear. But yeah, we can chat after, Lisa, for sure.
No problem. I'll edit the names out and I'll show you.
Cool. Yeah, no, we all appreciate it. So the basis of this, guys, is someone is taking your signature, getting money from it right away. And they're tricking you at the signing table by basically us waiving our security interest in it. Because when they get the money up front and go make more money, like that's the concept behind coupons. Like people, like the coupons is what our security interest should be every month because of that investment that we made as the natural man into a corporation. So every month, because they're leveraging our credit as the natural man, they monthly need to be giving us security interest dividends. So that's what people think of like the coupon to be like, oh, like this is just our security dividend for this month. There's some truth in that. There's some lies in that, but like, that's what people kind of associate that with. So what we're now going to do is we're basically going to come back to these companies and call them out for not giving us full disclosure at the signing table. If you guys knew that these companies are going to get paid the money up front and not wait 30 years for them to get paid back, and then they take that money, make more money with it, and you, as the person that created the money out of thin air, you're entitled to equity. You're entitled to interest in that loan, and we would have never agreed to waive that security interest if they told us, if we knew about this. So that's where we're going to kind of come back now, reacquire the original instrument, And like I said here, like, why can we come back and win a claim and really discharge these loans? It's because we're the original endorser. We signed the instrument with a corporation. We're the living man. They're a corporation, a corpse, a dead entity, a corpse, and they're getting the money up front. So us as the living man, we were the former holder in due course. We make a claim to and reacquire the original instrument. As a former holder, we're able to do that. And we can accept all the interest proceeds above $1 after administrative fees. So we're coming back. We're nunc pro tunc now. For then, you might have tricked me earlier, but not now. Now I am competent. I'm in my sound mind, age of majority, and I'm coming back to claim all of my security interest in that instrument. So most likely, the longer you've been paying on something, the more money you can potentially get after. I honestly have never won a claim for proceeds. I have only personally discharged securities. I've never got the money back from it. However, we should be able to do that. I just never did it before. So like I said, since we never got full disclosure that we're waiving our interest in this, it's really no disclosure and it's securities fraud. So especially if they're not going to give us back the original instrument, if they're not going to meet some of our demands during this administrative process, we're going to basically call them out and it's going to be discharged. So we'll dive into like the actual process now of what I did and how we're going to reacquire it and kind of set it off. But does anyone have any questions before we jump into that?
Yeah, I had a question.
Yeah, go ahead.
So on the reacquisition of the original deal, if they sell it to someone, how do you reacquire it if it's already transferred?
So obviously they won't give it. They're not going to give it back. And that constitutes for an automatic discharge if we properly put them in default through the administrative process.
Perfect. All right, cool. Thank you.
100%, brother. And just for anyone in the chat, I don't mess around with 1099As. I've never heard of success with that. I've only heard of like indictments with unlawful conversion. But I don't personally do 1099As. I just reclaim the equity.
Yeah, same for me. When I was in the beginning of my journey, I got onto the whole 1099A thing, and I tried with child support and a couple other creditors, and they definitely did not work.
Yeah. And you got to be careful on that.
Yeah.
And yeah, no one's really teaching the proper way to use 1099s. I don't use 1099s. I think they're more so for like corporations when they file taxes at the end of the year with the IRS. But like for us, like I don't even do taxes. I'm 100% exempt, non-statutory, non-commercial.
I don't think anybody's actually mastered the 1099As yet.
I have witnessed a process where somebody, and I put my hands on the vehicle myself. This happened in the state of Maine. They had the automobile. He bought it for his son. And he issued 1099s along with a UCC1 and a letter of rogatory and a Form 56 to TD Bank. TD Bank put a derogatory mark on his credit account, on his credit score. And he immediately called them and said, "What is this? I sent you payment." And he told them what he sent. And they went back and corrected it and said, "Yes, sir, you did pay us. We apologize. You can come back and get a loan with us anytime you like." And to my knowledge, he has now since purchased 2 other automobiles using the same process. But again, all of this stuff boils down to you being able to verbalize what you're doing in a manner that shows that you know the back end banking, the back office side.
You just hit the nail on the head there. If they can tell that you have no idea what you're talking about, they're not going to comply. They're going to wait until you try to get them into court, because most likely they know that you don't know how to sue them. So
Yeah,
you're going to run wild and do whatever. But yeah, that's key. And I'm going to continue the presentation. We are almost done here for the respect of other people's time. But yeah, here's the actual process that I've done to do it. And before we jump in, I know I've sent this to some of you guys, but this was like one of our statements here. You can see the total amount on this was $375,800. And June 14th of last month, we recorded in Muhlenberg County. Here, this is public record. You guys could literally pull up this document in the county, go through it, look at everything, figure it kind of out for your own. Because this is the evidence we recorded in the county on public record, basically verifying that there is no dispute between us and the SBA. The debt is invalid, it's unclaimed, and we don't owe any money. And I'll show you like all the evidence, but this is solely a cover letter. And we just give room for the clerk to stamp, to put the sticker on there. And now it's public record.
May I ask what category you were able to file it under, like in the county?
Miscellaneous.
Gotcha. Okay.
Cool. So, yep, that's that. And I'll be showing you how we're going to be building the case, how we're going to put them in default, and then how to record the evidence. Because this entire administrative process is just about building a case for a court, really, or for the public record. So really what we did, what me and Stone did for our client is we sent out 4 different mailings and then we recorded it all on public record. Everything, if you guys are going to take notes here. Obviously, everything has to be signed with your signature, notarized from a notary. And I always send out everything with my green return slip and certified mail. Yeah, feel free to take a picture, but we're going to go through each one of these steps. And real quick, administrative process, guys. If you don't know what that is, it's really an out-of-court process done via the mail to give the opposing party or whoever we're in this with a notice of claim upon which relief can be granted. So we're basically saying like, hey, for this specific example, we're saying like, hey, do I owe you money? And if I don't owe you money, my relief is going to be, I want you to set off the account. I want to accept all proceeds above $1 and you can no longer litigate against me. Stuff like that. But that's our notice of claim. And now the opposing party will have 30 days to rebut the claim point by point. Otherwise, through acquiescence, which is basically reluctant acceptance by them not responding, they're going to agree to the new terms that we laid out in the claim. Basically saying like, hey, do I owe you money? If I don't owe you money, discharge. So if they don't respond, that's honestly sometimes a good thing because we're going to show the court like, hey, like we asked them multiple times if we owed them money and they never responded. So clearly there's no dispute and clearly we estoppeled them, which is halt any further debt collection and any further litigation. And like I said, we do this by getting them into default before a party can kind of file a complaint against us in court. Once we get them in default, we can motion for a summary judgment in court as there's clearly no dispute. Like I said, if they don't answer, a lot of times we'll get back letters that just say like from the finance team, from the management team, there's no injured party, there's no signature. There's no notary on it, which means under penalty of perjury. So it's an unlawful response. So a lot of times you guys will be getting unlawful responses. They won't answer or they'll never actually prove that you owe them a debt. So that's why like we really recommend paying until this whole process is done so they can't get you to court prior because then it just makes things hard.
Can you do a motion for summary judgment prior to initiating a complaint, like as just part of procedure?
There's about 10-15 things that you need to file all at once. And one of them is a complaint with a verification of complaint, all with a motion for summary judgment. And a lot of the times what I actually do personally is I'll motion to show cause. So I'll basically like file into the court, like, especially if you're already in a court case, you can motion to show cause to have them produce the evidence that you actually caused them loss. On top of that, it's kind of a lot. It's kind of off topic, but we can chat after.
Yeah, and also on that, so you're kind of in that situation, you're kind of relying on the judge to make make some of those decisions if you want to get like that early summary judgment.
So your guys, basically, you've come to a process that's actually it circumvents this even.
So what we do is as soon as you file this as evidence in the county and the clerk certifies it, if there was ever to be a court case against us, we're first in line, first in time. We already have evidence showing there's no dispute for this account number. So literally all we would do is, like, if they tried to come against us, we'd have the certified evidence, just file into the court case, answer it that way, case dismissed. That's how we do it. We found that to be kind of the easiest way. I don't know if did that answer your question?
Yeah, sort of. I mean, file it into who initiated the court case in this theory, or in this hypothesis, or theory rather, yeah.
So
Like, would it
like
be
I said, this
something-
is what I've done. So it's not theory. I've done this.
No, I mean, I'm saying, like, is it them? Were they coming after you, or were you going after them right away? Were you the one who initiated it and the complaint and everything?
So in this case, in this right here, none of that happened. They completely cease and desist and removed all liens solely after we filed the evidence. Once we filed the evidence, a copy got sent to them. And at that point, they really have no other choice. If they refused to remove a lien, that's when we have to get a summary judgment. If you need a title to your car and they haven't sent it yet, that's when you go into court and get the summary judgment.
So all the evidence that you're filing is more or less on the public record, then you're sending them, like, under an affidavit of mailing, everything that you file on the record, all the evidence therein. So in hopes that they're like, okay, this is dropped, we're done with it. So you don't have to go the complaint route necessarily.
So this checkmates them. This estoppels them because, like I said, they acquiesce, they agree to the new terms that it's discharge. They can't litigate against us. There's no dispute. And once you get that on county record as evidence, it's fact and law. So they can't come against you later to try to litigate against you because we're first in line with the evidence of no dispute. So you don't even really have to go to court with this. You just need to get evidence on public record. That can be a UCC1 statement, local county recorder. Obviously, the court is public record as well. But there's many ways to get remedy in a lot of these situations. But this is, like I said, what I've personally done.
Can I have you go back to that first page, the one before this one?
Yeah.
Thank you.
You wanted the screenshot.
Yeah, please.
Let me go find. How do I go back here? And then
I mean,
what about yeah. Or
I was gonna say, if you can't figure it out, that's okay.
message me just to save the time. Message me on Facebook and I'll send it to you.
Okay, thank you.
100%. I got you.
Hey, Josh, I just wanted to add one thing.
Go ahead.
So we did this with my wife's Audi. In 2021, we bought a Audi Q5 through Carvana. It's serviced through Bridgecrest. So in like January of this year, we sent them an instrument. They ignored it. It went to Treasury Management. I defaulted on the instrument. I did a notice of dishonor. I did the whole process, right? I did an affidavit of account showing that there was nothing owed and that they actually owe her $81,000. Filed it with the public record, everything. Woke up one morning in end of April, car's gone.
Car's what? Dawn?
Gone. They took it right out of the backyard. It was an unlawful repossession, but I know possession's 9/10 of the law, so I immediately took $3,000 up there, got the car back same day, and I told them it was for redemption, not for restatement. I said, oh, what's the redemption cost? They said $31.39. So instead of me taking $31,000, I took $3,100. And we got the car back the same day. I gave them notice of unlawful repossession, got them on recording saying that they unlawfully repossessed the car. And I haven't heard nothing from them, right? But we still need to get that money back. But I haven't had time to do the lawsuit for my wife because, you know, people have to stand on their own. You can't do it for them. So it's a little difficult, but that's kind of what you were saying. But we did the whole default process, registered it. They still took the car, you know? So
Yeah,
in that
if you didn't
situation,
have a title, you'd have to proceed with summary judgment and get the title through a writ of execution, most likely.
yeah, that's the next step I gotta do. Okay, continue. I just wanted to.
So, and talk to Stone about that, because we're doing that for one of his right now.
Cool.
Did
that
did
exact same thing.
Carvana put anything on the credit report?
Eventually, yeah, but they haven't touched the credit since April.
So you can literally, so how much money are you needing to get back? You said 3,100?
I already got it. I got it the same day back.
Oh, you got no, not the car, you get the money you had to pay.
Oh, I didn't get anything back yet.
So honestly, the easiest way to handle that situation is just to sue for them furnishing your personally identifiable financial information to a non-affiliated third party, which would be the credit reporting agencies.
Yeah, I
So
got them
just
on more
for-
than that.
Do what?
I got them on more than that because there's no contract with Bridgecrest. The only part Bridgecrest has is in the voluntary authorization for ACH payments. That's where Bridgecrest come in, but on the security side, they're the servicer of the securities. But on the customer facing side, they act like they own the title or all this other stuff. So I can hammer the shit out of them, but I was just curious because it kind of linked up with your process. What would you guys do in that situation where they took the car after you've done all that stuff?
Message Stone. Wanna connect with each other so I can just continue the class,
Yeah,
because
yeah,
that's
I'll
kind of
tell
like
you.
a
Yeah,
different topic a little bit.
I'll drop my you on social media?
Yeah.
I'll just
Gosh,
drop my social media, Facebook or Instagram. Just hit me up with a message.
all right, brother.
Cool. And now we're about to get into the sauce. This is the actual sauce, the exact stuff we've sent out to actually get the liens removed and to get a set off of the account. So the main one, like I kind of gave an instruction or that I talked about earlier in the call, was it's all about making a claim. Does someone have a claim upon which relief can be granted against me? Do I have a claim upon which relief can be granted against someone else? That's the only way we can get to court, like I said. So the first letter we're going to send here, and I'm really not going to go through all of these. I'll let you guys kind of read it on your own and comprehend it, look stuff up, write down questions, come back, ask me questions if you have questions. But I'll go over each form and kind of tell you what they do and why we're sending them. So first one is an affidavit for claim, evidence, reason, abatement, therefore declaims. So really, we're asking the creditor or the opposing party if they can produce a claim against us. Like, hey, you have 10 days here to really produce a claim for evidence showing loss. Like I said, financial, mental, physical loss. Can you actually show me evidence of it? And you guys, this is one of the only forms that you guys are gonna have to fill out kind of by hand. So I will send you guys it filled in. You'll know exactly what to put in each line, but really you're just putting your name and any derivative in all these lines. And you're just asking them like, did I cause you injury? Did I cause you deficit of any type? And that's the biggest thing, is making that claim. And another one we send out is basically saying like, hey, we're now reacquiring the original instrument, otherwise it's set off. But the biggest thing in court, when you actually get to court, like I said, is claims. Can they produce evidence of loss? So the first thing we're doing is, hey, Small Business Administration, hey, Truist, hey, Chase, hey, Toyota, do I owe you money? Do you have evidence of loss against me? That's the first thing. That is the main thing. Does anyone have questions on that?
So can you send the same to the debt collectors, like asking them what's your loss, basically?
Yep, anyone.
Yeah.
Anyone that's trying to say you owe them money. Because like I said, I could come up to you right now and say, you owe me money. I filed my complaint into court yesterday, and if you don't know what you're doing, you might lose. But obviously that's not going to happen. But it could be the same with these companies. Like, do they just randomly want me to pay them money? Like, how can they prove that I actually owe them money on public record in court? And that's through a claim of evidence. So that's what we're asking them. Do you have evidence against me? That's the main thing.
And where do you send them to? Who are you sending these?
So we sent him to the CFO of SBA. For my personal situation was the CFO, Erica Gaddy of the SBA. You can send them to the CEO, the CFO, the registered agent. Those are probably the three people. But yeah, we did the CFO in this.
Also, you can send it to the indentured trustee.
100%. I did the CFO. I'm sure any of those can work. So that's the claim. That's like the biggest thing, because obviously, like we saw, like I'll even search it up. Failure to state a claim. If there is no claim stated in court with evidence, case dismissed. You guys can look it up. Failure to state a claim. It's basically a defense saying if even if it's true, even if the factual allegations are true, like even if, yes, I do owe them money actually, or like, yes, this or that, like, yes, even if it's true, if they're insufficient to establish a cause of action, and the case should therefore be dismissed. So basically, let's see, cause of action is a set of predefined factual elements that allow for a legal remedy. So that's a claim upon which relief can be granted. There has to be some sort of loss where by you giving them money or by you in getting to court and having to remedy the situation with them. What was I saying? Basically, there has to always be a claim upon which relief can be granted, some sort of loss, and then some sort of remedy to basically cure the case. So a lot of cases you guys will see, like failure to state a claim will get a case dismissed immediately. So that's why the first thing we do is, hey, do you have a claim? The next thing we send, and this is all together. All of these get sent out in one letter. So affidavit of claim, also debt validation. This is where we're really asking them to validate the debt, as a lot of you guys are familiar with. This is just a very simple debt validation letter pursuant to obviously 15 USC 1692. If you're unfamiliar with 15 USC 1692, definitely research that. That's the FDCPA. Also research any other like 1681, 15 USC 1681, definitely study that. But when I send you guys these, before you just go rush and send them out, read them, understand it, know really why you're doing what you're doing, and the goal of it, the purpose and the intent behind it. So debt validation, obviously pursuant to 15 USC 1692, they need to verify the debt. They need to prove to me that I actually owe them a debt, that the debt is real. On top of that, any debt collector that you send this statement to has to answer all of these questions according to 1681. Name. Some of one of the best ones is where the actual security instrument is being held. Where's the location of it? Because the thing is, they know that they've sold it. They know that they're participating in fraud. And when we ask them questions, they know they can't answer truthfully. If they lied, the consequence is worse than not answering. So that's why a lot of times you guys won't even get responses, because they lawfully can't respond. But
I tried to, through my mortgage lender, I tried to file a RESPA, and I didn't realize in the full RESPA that asking for the security information surrounding security is considered unduly burdensome. So I was trying to figure out how to get around that myself.
When you sent out that qualified written request through RESPA, did they respond?
Well, no, you're not the RESPA response. It was actually to the bank. Yeah, and the bank did respond. The bank had their attorney respond, and the attorney said it's considered unduly burdensome under RESPA also.
Did let me show you one of my RESPA letters real quick for everyone. This is for anyone that that's either in foreclosure or has a mortgage they're trying to discharge. This is specifically like our brother said, under RESPA. It's called a qualified written request. And does this look like the one that you sent? Like, did you ask like very specific questions that they either ignored or didn't send back?
I didn't know RESPA. I thought RESPA was an act and you're basically initiating the act to the bank saying, hey, you're obligated to give me this information under RESPA. I didn't know it was like an agency that governs it that you send it to for them to look up on the financial institution.
No, you're right. RESPA is just the Real Estate Settlement Procedures Act.
Okay, yeah.
So they,
So that's
like you
not
said, they
like
have to answer. They have 20 days to respond, and they have 60 days to basically settle the whole matter. So if they don't respond within 20 days, what I'm about to do here is put an injunction on these people. It literally says under RESPA, if they don't respond and they don't answer the questions for you, you can proceed to put an injunction on them. And at that point, an injunction is like the highest form of evidence against litigation, debt collection, any of that. So they have basically 20 days to express that they received this and 60 days to lawfully respond and answer all the questions. If not,
So I can file an
go for an
injunction on the lender
yes, sir. Yep.
without going to court, like just handing them an injunction?
You need a judge to grant the injunction. So you
Yeah,
can
okay.
file it into the court and just have them sign off on it in order to get an injunction relief.
That's with your summary judgment and everything.
Yeah. Yeah.
Gotcha.
Cool. So yeah, that's RESPA. Hit me. Anyone that's either in foreclosure or is trying to discharge a house, you message me for this letter. You can do your own research. Like I said, not legal advice. I've never done this on my own. I am right now though. What we're talking about for today is really just that SBA loan and any type of credit, like a credit card or really any of that. So what was that?
I said, does this process also work for a corporate landlord with your lease?
You can't. No, there's a whole other kind of process. Here, let me mute out people. Oh, you're just echoing. Honestly, no. I do know a ton of people that have gotten out of their rent and still haven't paid the rent, but I'm pretty sure it's through a different process, and I've never done it myself, so I can't speak on it. You just stay muted if you're not talking.
Can you hear me now?
Yep.
Okay, I was just asking because on my rental lease, it says Truth in Lending on it.
Okay, so it definitely probably got securitized, so it is a security. I'm not 100% sure on your current situation, so I shouldn't say much, but you definitely need to make a claim to that original instrument that you signed.
Okay, I did do that also. And they gave me one back with a mechanical signature. They removed my wedding signature.
Okay, so if anything, you won't be able, they're not going to be able to evict you.
Okay.
I would need some more clarity on your situation, and I might not be the best person to talk to about that.
Okay, I'll just message you personally if it's okay.
Yeah, for sure. We can break it down in chat for sure.
Awesome, thank you.
You're welcome. So these 3 letters, guys, is what you send out right away. If any of you guys, I know I talked to some of you guys, you have SBA loans, so literally it's going to be the exact same thing I did. Or if you have like a Chase card, a Bank of America, any type of debt where people say you owe them money, you want to send these 3 letters to that creditor. Like we said, I did mine to the CFO. And on top of that, you always need to send like a service affirmation, like an affirmation of mailing, basically saying like, yes, I affirm under penalty of perjury that I did send these documents out. And we're going to be doing one of those under 2 witnesses and one of those under a notary. So we're basically like saying like, hey, these are all the letters we're sending out right now. I affirm under penalty of perjury that I put them all in a letter. I sent it to, this is just an example here, Bob Smith on this date via this certified mail number. And that really just proves that they received it. So you said when you set off the balance on a credit card, do they close the account or can you still use the card? Me personally, I've gotten my accounts shut. That is why all credit needs to be done through business. all credit is done through business, because I think there's a way to not get them to close your account. I've just never done it. However, when you're doing it through a business and you can PG and LLC over and over and over again and get basically 150, 250 grand per LLC, then it doesn't matter if it stays open. Like like I said, this loan right here was 375K that my client just got for free. Like, we're good, close the account. But yeah, that's why it's like rinse and repeat through different entities. That's why you need to perfect your personal credit and use it to get business credit.
So right now, and like if I have, for example, just normal credit card, that would be wise to kind of max it up and then use the process, right?
Everyone's situation's different. It depends. So anything on your personal side that either has a late payment, is derogatory, is way too much money for you to ever pay back, any of that, like, delete it, get rid of it. And we can kind of go through how you're going to use the GLBA, the Graham-Leach-Briley Act, to get stuff removed and deleted. However, to get business credit, you need to have a built up personal portfolio, which consists of at least 10 accounts, 5 of those being primaries, no late payments, under 6% utilization, less than 2 inquiries per reporting agency prior to us getting business credit, which doesn't go on our personal side. So that's 2 different things you need to really think about. One is you need to kind of have 10 good accounts, whether that be trade lines, authorized users, whatever. You need 10 accounts before you can get business credit. So I wouldn't necessarily start removing everything. If you have accounts in good standing, you're paying them on time. They're obviously most likely low limits, under 5K, under 10K, 10K or less. So yes, keep paying those. Really make sure you have a good personal side to then get the business side and then discharge everything from there. Did that help, Anna?
Josh, I want to add on to what you said real quick.
Go ahead.
My mentor, one of my mentors actually was mentored under Carlton Weiss. And Carlton Weiss taught him that when you go and you sue, add in there to remove the name completely out their system so that you can go back and get the same thing again. And he showed like his stuff being done that way. So I seen it proof. But you just have to add that in like what you're seeking. Do that make sense?
100%. And I thought that would happen as well, because obviously, like, when you apply for a credit card, 99% of the time it's an algorithm. It's a computer generated. So if nothing's reporting on your Equifax, TransUnion, Experian report, then I should be able to go apply with that same company again and get the same result.
Yes, you just have to make sure you put that in your your deposition, like what you're seeking relief, like that needs to be put in there for that to be that way.
Yep. To get stuff deleted, we basically call these companies out for not giving us an opt-out disclosure upon signing that. So according to the GLBA, I'm not sure if anyone's familiar, you guys can all look it up, but whenever we go into a credit transaction, the creditor is supposed to give us an opt-out. They're supposed to say like, hey, full disclosure, we're going to share all your personal information with third parties. Oh, but here's an actual opt-out. You can opt out with this form. Sign it if you don't want us to share that. The thing is, they never give us that opt-out form, at least for my experience. I've never got an opt-out form. That's why nunc pro tunc, we can come back now, basically say that we never received full disclosure. Not receiving full disclosure constitutes as fraud. The fact that they used our non-public personal identifiable information to commit fraud, a crime, that's also identity theft. So just that alone will get anything removed off your credit report. And I do have templates for that if anyone's interested.
I have a quick question that ties into the, when you're applying for credit. Somebody posted on Facebook the other day that they were trying to do this over and over and they weren't getting that, a really high score. And then they said something about with their address. And I don't know if they had created another address, maybe for a business entity or something. I'm not clear on that. But the thing is, I went through bankruptcy 3.5 years ago. And I've been living in abject poverty until I just started getting my husband's Social Security. So I now have some funds coming in. But anyway, I live in a house that's it's effectively a 2-flat. It's on record as a single family, but it used to be single family, then a 4-flat, then they changed it to a 2-flat, and then on record, I don't know, 15 years ago, it's a single family. Every single piece of junk mail that comes to my house says the address and then upper 1 and lower 2. And for some reason, it's like the address is, there is no upper 1 or lower 2. I mean, number 1 would be the ground floor and that anyway, so my address is all screwed up. But this guy was saying that he did something about using another address, and then that wasn't like going through. So you were talking about how it's all automated. So I guess it just seems like everybody who, when I opened a new bank account, I was at a credit union a couple months ago, it all comes up on the computer with this stupid upper 1 and lower 2 on it. And it just seems like the system can't get rid of it. Nobody can deal with it, you know? So I don't know if you have any idea on that about how everything has to match with the system, you know, with whatever's in the database. And I don't know how to change it. It's been screwed up for at least 15 years.
And you said that was on the business side though, right? Or was that personal credit, business credit?
I'm not sure what that other guy was trying to do, but what I was going to do was I was going to try to finally get a credit card, because I've had no credit card, you know, for a while. Everything was, you know, discharged in the bankruptcy. The thing is, the house went into foreclosure. Fannie Mae is still trying to steal the house and stuff. And by the grace of God, I'm still here. And I've intimidated those lawyers, but the thing is, it's just a day-by-day thing. When is the eviction notice going to come? You know, but anyway, you know, in terms of like the whole credit thing, I know that this whole address thing is going to be important, you know, so.
For sure. So definitely, like, I know for sure on the business side, the address of your LLC has to match your website, has to match your 411 phone number. Everything really needs to be aligned on that, or you will get denied. On the personal credit, I'm not too sure. Your best bet would just be to probably open a PO box. If you're actually getting denied because of an address or something, I would send a notice to all the reporting agencies, just telling them you never lived at the address that they have on file, any of those files, any of those addresses on file, you've never lived there. And that PO box is your new address going forward. Maybe like an old address has like, they're tying it to like you not paying money back, or I'm not really sure. We can chat though, message me on that.
Yeah, okay. Yeah, because I mean, I didn't even apply for the credit card yet. I'm still just, you know, just getting the Social Security, and, you know, when is the food stamps and Medicaid going to end and all that. So I'm kind of in a transition time, you know, but yeah, I would love to get business credit, but you know, I'm just trying to get this all figured out. So
100%. So I recommend everyone to get a copy of your credit report, especially if you don't know your score, especially if, you know, you're blocked getting credit, or you don't have as much credit as you like. Or if you're just looking for more credit, I'd recommend everyone to get a credit report. You can call up the reporting agencies, just say, hey, send me my credit report. Or I know a lot of people recommend Identity IQ. You can get a credit report from all 3 bureaus for $1. So if any of you are struggling or are looking to get credit, the first thing you need to do is analyze where you are now by getting a credit report. And then if you guys send me your credit reports, I can look at them, kind of give you a game plan on the next best steps and exactly what you need to do to go get either more personal credit or set you up properly to go get business credit.
Hey, Josh, may I add one thing about the business credit?
Yeah, and last thing, so we can keep going, but go ahead.
So I got business credit on a null corporation. The corporation's dead in the state, but they still gave me credit, and they recorded it as a null corporation. And then recently I found out that Capital One Auto Finance is a dead corporation too. They're completely dead. They're not licensed to do business in any state, but they're getting mad credit because they were absorbed by Capital One NA, but they're a dead corporation too, and they're getting credit. So the corporation doesn't even have to be active. It can be null and you can still get credit because, all these corps are dead entities anyway.
Yep, 100%. I've never gotten credit on an inactive one, but I know you can just go back and make it active again as well.
Cool.
Yep. But cool. Does any last questions relating specifically to what we're doing in this first round of mail?
Just one last thing, Josh, real quick. So all 5 of those things you put in one envelope to send off?
Yep.
Cool.
Make sure if it needs a notary stamp, you get it notarized. If it needs your signature, sign it. The templates are pretty good though. You'll know exactly kind of where to fill stuff out. And like I said, this is the most important one. You need to handwrite this, and I'll send you everyone a picture of this. And yep, it all goes in one form or one envelope, certified mail, green return slip.
I have a question for myself. We have a mortgage account that I'm planning on doing this for, and the mortgage is in both of our names. Do we need to both do a separate one of each form, or can we put both of our names on one?
Sign together on one form.
Thank you.
You're welcome. The one that's handwritten is the affidavit of claim. I'll send that to you here. And also, guys, you always want to keep your originals. The originals is what is the evidence for court, for public record. Always, if you're signing something or getting something notarized, make a copy and then send out the copy. Cool. So that's the first notice. We're going to now go to the second notice. And take notes. The second notice is sent 21 days after the first one. So you send it, you just wait 21 days, you wait 3 weeks, give them a chance to respond. Most likely they won't respond or won't lawfully respond. I can almost guarantee it. If they do respond like lawfully, the only lawful response, like I said, is a point-by-point rebuttal of your claim under penalty of perjury, signed by actual person, not just a corporation, not a management team, not any of that. Most likely, though, I guarantee it, they won't respond or won't respond lawfully. So 21 days after, now we're basically saying they're in fault. They either didn't respond or didn't respond up to our liking. And we're basically saying like, hey, this is now a fault and dishonor. You didn't respond to us. And also, if you guys heard of a right to cure, this is also kind of a right to cure where we're giving them another chance. Like we're like, well, you already didn't meet my needs, but I'll give you another chance, like just to be nice. Here's your last chance. But on this one, we're basically saying like, we're basically saying, if you guys do not respond to this and rebut this, you're agreeing to the following terms. The following terms, the balance is zeroed. I get all rights, titles, interest, and equity in the property, release all collateral. And by them not responding and defaulting here, they're agreeing through acquiescence to all these new terms.
Is acquiescence another way of saying conditional acceptance?
No. Conditional acceptance is saying like, hey, I'll pay you if this is real. Acquiescence is by you not responding. Like, let's say I say, hey, like, you're weird or something. If you don't come back and say like, oh, I'm not weird, or like defend yourself, then you're agreeing that, yes, I'm weird. Or like, that's a weird example, but does that kind of make sense?
Yeah, it does. It was when you highlighted there, said you're agreeing to these terms, which I understood conditional acceptance. I thought that was what you were trying to say, but I get you now.
Yeah, look up the definitions for sure.
Yes, yes.
I actually sent a debt validation to Mr. Cooper, aka Nation Star, and they never recorded to public record. And then 10 servicers and 6 attorneys finally, took my home or whatever. But this same debt validation that you're, presenting right now, I actually did. And I have them in default, and pretty much that should cascade everybody else in a sense, because like I said, they
Yeah,
never
well, here, the difference
recorded
is
to public record.
I don't know what you did. We really don't know everything you did. If you
Right.
just want a debt validation, that's not enough. The real evidence here is this affidavit of claim. Like I said, court can only happen if there's a claim against you. If you have a claim
Right.
against someone else. On top of that, you might have had to file that evidence on county record or get a summary judgment in court. If you don't do that, like, where's the proof that you did any of that? Right? Like, they can do whatever they
Right.
want. These people, these companies aren't gonna help us. Like, it's us versus these companies.
Oh yeah.
And we need
Yeah,
to
it
help
is.
each other. But for sure, it could have been for many reasons. Like, feel free to message me. We can maybe talk about potentially getting it back. I'm not sure. Because yeah, you definitely got your rights violated. And yep, it's all recorded, Bonnie.
Absolutely. Thank you.
And yep, no response is a green. Yep, yeah, no, exactly. They do that to us all the time. Traffic tickets. You get a traffic ticket, within 3 days, you accept it. If you reject it within 3 days, it's rejected because you are rebutting it. If you don't rebut it, though, they're basically saying through the acquiescence, by you not saying it's not real, you accepted it. Goes, yeah, both ways. Like, even if they whenever they send you back letters that are unlawful, we need to write deny on them and send them back. The reason we do that is because, like, it's acquiescence. If they send us something and we don't rebut it or don't deny it, it's good. It's now a fact, basically. Obviously, like, we can come, like, really, it's not that big of a problem. If we know what we're doing, we can come back later and deny it. But every time you guys get a letter that you don't like or that's not what you wanted, deny it and send it back to them. That's key. Yeah, replay is going to be sent out.
They usually send the responses just regular mail. How do they even prove that they even send me anything?
Yeah, exactly. Right? Like, it's an unlawful response. It's not even a response. So, yeah. These companies will do whatever. They never sign it. You'll never see, like, someone's name signing it. It's never a wedding signature, never, ever. So really, we're just building the case here. Still, I don't know if Stone is still on, but oh, here he is. He's about to join. But they sent us back, the SBA sent us letters. Stone can pull up the exact letters they sent us, but they're random letters. They're on company letterhead. No one signs it, not notarized. They didn't rebut any of this. They didn't respond to any of this. They just they just say, like, no, it's not true, or something like that. They try to trick you. They try to beat us down, and they expect us not to know what we're doing. So they run all over us. But the letters we got back from the SBA, we write deny on them and we send them back. That's one more thing that's key as well.
So you open the letter and then what? You have to seal it back?
You can put it in a new envelope. Just get it back to them saying deny with red ink on it.
Okay.
Yeah. Denied without dishonor or offer rejected is fine.
Yeah, Stone, I was just saying, because, like, the SBA responded to us. Like, they tried to say, oh, no, this and that, your debt's real, but it's an unlawful response. So once we got all the evidence, we recorded the evidence, and they basically got checkmated because they can't do checkmate at that point.
Yeah, and like 90% of the time, it'll be like, thank you so much for taking the time to send us a letter. We're in receipt of your correspondence. Blah 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 blah. It's garbage. Just to throw us off the track. Yes, same for a ticket, Andre.
Yeah. Yeah. Stone, you actually you're in that
Yeah,
now. Right?
yeah, I literally yesterday just sent a parking ticket back to the Atlanta PD. Just
Yeah.
yesterday, same method.
So
Sign it,
we'll let you guys
offer
know
rejected, sign it.
for tickets. Yeah. It's all crap. And you know what I tell people too, because I have a international driver's license and international driver's permit. You never want to consent to these officers. If you consent and give them, let's say, your driver's license, you're basically consenting and putting yourself into their jurisdiction. And everything is contract and consent in this world.
Yeah, and if you're confused in the moment, then like for the love of everything, do not mention the word sovereign citizen, because they're literally trained at the police academy to freaking smack your window out, drag you out of the car, and haul you down to the jail. Just sit there and say, I don't understand, I don't understand, I don't understand, I don't understand, until
Stone, not to cut you off, Stone, but what I
this.
say is, guys, you don't have to identify unless there's an injured party. What, they pull me over for speeding, they pull me over for running the stop sign, not putting a blinker on. Who did I hurt? Who did I hurt? I'm traveling. I'm not identifying myself. I'm actually not even in commerce right now. That's what you need to say. I am not in commerce. I am non-commercial. I am outside of your jurisdiction. I'm operating privately. If there's no injured party, you don't need to identify me, and you can now get on your way. And that's why we do stuff like the schedule of fees and injunctions on public record to really get on do not stop and do not detain lists. But yeah, I wouldn't mess around with any of these cops.
A motor vehicle is by the motor vehicle department is 10,000 pounds or more. All these automobiles that we're riding around in are not vehicles. Question them, what is a vehicle? It's 10,000 pounds. If you're riding around in a car or even a small SUV, it's not 10,000 pounds.
Interesting.
The other day I got stopped by FWC for fishing, and they were trying to take me to jail because I wouldn't identify myself.
Oh my.
Yeah.
Man. Yep. I'm sick of that stuff. Like, we shouldn't have to worry about these things, but we do, which is sad. And that's why we really need to team up together, be a community, get in, because if enough of us do it, the system collapses pretty much overnight. So really, like, if enough of us do this, get these people on record, we can stay in court together too.
Another thing on your traffic stop, the patrolman
last thing, go ahead.
a certificate of authority to do the business for the Department of Motor Vehicle. Nobody has a certificate of authority for any business that they're doing.
Yeah, usually it's like a contract to collect services too. Contract. You're mute out if you're not talking.
Hey Josh, I had a quick question.
Yeah, go ahead.
In the chat, a couple of us asking about, if say for example, our mortgage is transferred to a new lender, who do we send these to? Do we send it to indentured trustee of the new company? Do we send it to the old one? Do we send it to a lender themselves? Where does it go?
So, I have to kind of, like I said, I've never been in that situation myself, so I can't right off rip kind of tell you what I would do. Honestly, probably everybody. Why not? Better safe than sorry. But probably whoever you're still sending your payments to, which is probably the new lender, right?
That makes sense, but would it be the indentured trustee of that new lender, or would it be the trustee or the lender itself? Who do these go to?
The trustee of the new lender or the lender themselves?
Well, say if we're not worrying about between old or new lenders, where do these documents get sent to?
I do CFO. I do the CFO. Because he's really the one in charge of the accounting, the bookkeeping.
Okay, I wasn't sure if it was sent to the trustee himself.
Nah,
or their self?
I've never like done anything with the trustee. I know there's stuff out there. But nah.
How
But
do you
cool.
rent cars if you have no license?
This constitutes as a state permit or a state ID. So, I mean, I've never like went to go rent a car using this. I don't think they could deny me. I'm not sure. On that one, not sure on that one.
Okay.
Wait, what is that?
International driver's permit. It's like a driver's license, but it's outside of the United States of America jurisdiction, outside of their corporate world.
What kind of tag do you get for that? On the, what do you put on the car?
So full disclosure, I still have a regular plate. I just use this if I end up getting pulled over. But I do know my mentor has a non-commercial plate, which is still through the DOT. So any type of like, because my mentors try like a tribal plate before, those will get you pulled over. Those don't really work. You want to get a non-commercial plate from the DOT. And I've never done it, so I can't speak too much on it, but that's what I would do.
Okay.
For sure. The biggest thing though is like I explained, like if you get pulled over, just explain like you're non-commercial, you're not operating in commerce right now, you're just traveling. It's your First Amendment right. So if they violate you, there's going to be a problem, and that's why we usually have a schedule of fees on record.
Okay.
But yes, we if all you guys don't mind, we'll wrap this up and then do questions at the end. But for this specific letter, does that make sense? They're basically defaulted. We're giving them a chance to cure it, and basically if they don't, then they're acquiescing to new terms.
Yeah, that's good.
We can keep going. And obviously every mailing gets sent with the service affirmations. Always remember that. Witness and notary. This is exactly what I did with every mail.
Do you think witness is not enough?
No, it is.
So why you choose to do two? Like just to be safer?
Yeah, so like the notary is more public, witnesses are more private, but a service affirmation in itself is just you affirming that like, hey, yes, I affirm that I sent this stuff out. And obviously affirm is like under a penalty of perjury where you can't lie.
Yeah. What do you think about that? You can do service at the post office. They kind of check what you're sending and put like a stamp there. What do you think about this certificate?
I've never done it. I bring my stuff already with like the tracking number on it, and everything's already filled out before I get there. I just hand it to them, pay them, and leave.
Yeah, I know.
Yeah.
You just didn't use it, but there is an option.
Yeah.
They can do it at the post office as well.
No, I wouldn't let them see your personal stuff.
I think she's
Well, they just see the title on the document and they confirm that it's what you're sending in the envelope.
Okay, well, what I do is I write that certified mail number on the letter. So like it's undeniable proof. Like how would I have known the number to put on that letter unless I put it all together, right?
Yeah, but you need to prove that you actually like send, that you actually put those documents in the envelope, because that, you know.
An affirmation is enough.
Yeah, okay.
Yeah, but no, I agree. That sounds awesome. But affirmation is always enough. Yeah, and like Stone said, PO box is always great, especially doing business out of the post office is always great. Yeah, especially because I know I was talking with someone, and you never really want to have your house in your personal name where you rest your head. So we can chat about that too, but default and dishonor. This is the third mailing, second to last mailing, where we're basically saying like, hey, now you guys are officially in default. You guys have officially acquiesced to the new terms. Basically saying like everything we've done so far. I'll let you guys read this on your own. But basically we're just saying that they dishonored us. They didn't respond. And now they're in default. fault in dishonor, acquiescing to the new terms. Another very important one that we sent this time, and honestly, like full transparency, full disclosure on everything we did. We didn't get this letter here until about the third week, the third mailing. If Stone, I don't know if you can attest to that, but we actually met with our mentor when going through the discharge, because this was one of our first big discharges. So we obviously seek mentorship, we seek guidance. And so technically what I'm saying is this letter here could technically get sent out the first time, but we did it the third time. So it really doesn't matter, but you do need this in your mailing. And like I said and went over earlier, this is when we're reacquiring the instrument. We're asking for evidence of negative accounting with under a certificate of finance statement, which really is evidence. If it's not signed under penalty of perjury, we're not accepting it. But we're making a claim to the instrument and we're accepting all proceeds above $1 after administrative fees. So this is just making a claim to the instrument. Default and dishonor, just went over that. And then, like I said, every time you do the service affirmation. So that's 3 days after the fault, the notice of fault. 3 days later, it's a default. And then the final one is an estoppel, where through the acquiescence, by them not rebutting our affidavits point by point, by them not providing evidence of loss, they have now defaulted. They're in acquiescence to the new terms. And here's our estoppel notice. This is all we've sent. And by you dishonoring us and basically having no dispute with us, these are all the things that you've agreed to now. And this is our estoppel notice. You can no longer litigate against us, no longer collect debt, all of that. And I'll let you guys kind of read it here. We're basically saying, like, now you're in 100% dishonor. There is no more right to cure. This is it. Like, we're done. We don't owe you money. And don't try to come after us in the future. On top of that, like, we just affirm through an affidavit under penalty of perjury that we have not received any responses or any lawful response. We haven't got that. We send that to them as well, just to show them, like, hey, I'm affirming that you did not, lawfully respond to these. And then from there, all of this gets recorded on the public record 7 days later with all the green return slips scanned, all the receipts, all the mailing, all the originals, a cover letter, which is what I showed you guys earlier, and I sent to a lot of you guys, that cover letter, and an affidavit of debt denial. So you basically say, like, who you are, where you live, what you did, like, we started this kind of April 11th here when we got this first statement from the SBA. It was 378,000 at the time. When we got a discharge, it was like 375. And we're just kind of laying out the process, basically saying, like, we asked them for evidence. We asked them for a claim against us. They didn't give anything. I made multiple attempts, several attempts. Like, I really tried. And then obviously you put some state codes in there saying that they didn't validate the debt. It's now discharged. This is all then recorded with the county registrar. And basically now it's evidence of failure to state a claim. And if you have that on public record, first in line, first in time, no further court proceeding can happen. And congratulations, you've officially discharged your credit. Does anyone have any questions on kind of that mailing process?
I did have a single question here. So technically, once it's discharged after the record on public record, what do you do if the company doesn't respond by closing the account for debt collections?
If they don't respond to closing the account, can you
so for example, you have an auto loan and you have, say, the car is 50 grand and the account is still open after this, and they're still trying to collect payment after all of this, what do you do?
It depends. Is it unsecured? Is it secured? Is it personal? Is it business? It really depends. Like, it's a game. This is all a game we're playing. So really, like, for the car, if they're gonna still collect the debt, like, is it affecting you? Like, are you like, you know what I mean? Like, it's a game. Like, if you don't have a title to the car, you need to get a summary judgment with this evidence in court, where one of the things that they acquiesce to is to release all liens, to hand over all titles. And when you get that summary judgment, you can get a writ of execution from the judge, and they'll actually have to give you like a title or close. You know what I mean? Like, they'll have to give you the title if that's the case. For our case, this was it was pretty smooth. The SBA, they're a government agency, so they probably understand the laws a bit better than some of these corporations that do whatever they want. So they literally, once we sent them the certified evidence on record, liens were released. Haven't heard from them since. It's been since June 14th. Currently August 1st, full disclosure, it's been 6 weeks now since we've heard anything from them. So yeah, it all depends on your specific situation, your goals, your intent, but we can chat about whatever.
Thanks, Josh.
Yeah, 100%, brother.
So basically, if the company still ignores you and trying to, you know, harass you, whatever, the ultimate step will be go to court and get the summary judgment.
100%. Yep. Because basically you're telling the court, like, hey, there's no dispute. I'm now seeking summary judgment.
Yo, Josh, can I say something kind of on the court
Yeah.
thing?
Yep.
So in my experience, my results with getting remedy have been a lot better when the intention from the beginning has been, okay, I'm going to do this. I'm going to go through the administrative process. I'm going to give everybody a chance, and I'm going to set this thing up and put myself in a position to take it to court.
Yeah.
When I go with that intention, oftentimes it doesn't even make it to court. But when I go with this intention, like, okay, I'm just gonna send this letter and then hope that they just bow down and do everything I say, I am like 0 for 20 trying to do things that way, right? Always set yourself up like, hey, if I'm gonna have to go in front of a judge with this, what do I want to, what do I want to have to say? What do I want to be the case? Like, is the judge gonna, rule with me in my favor on this? And so I don't know, just kind of want to throw that in there.
100%. That's why we do things like the new contract terms. We're basically saying, like, if you don't respond to us or can't prove that we owe you money, these are the new terms. And that's what the judge is going to look at, because that's our relief, our prayer in equity, our relief. And they're going to give a summary judgment to that. And now we can get a writ of execution to have them perform on anything they're still refusing to do. Like, send us titles, stop calling us, whatever.
So essentially, you want to come in peace, is the way you're saying.
Wait, say that one more time. You want to what?
So, sorry if I'm not coming in through too clear. So
No worries.
really, what you want to do is come in a peaceful manner with it.
Always,
that too.
always, man.
Yeah, that too.
I always tell them, hey, I come in peace, non-destructive, seeking a resolution, and you just kind of set the bar with that.
Okay. Thank you.
What kind of court one should go? Like county court or district court, or which one of those?
I'd say it's gonna depend on the situation in the case. But for this, your local court for this, your local county court, it literally could be small claims, it could be district, it could be federal. I don't really think it matters.
Okay.
Yeah, it really doesn't matter. We're just going for a summary judgment. I'd probably do a small claims court, because the higher up you go, the more sophisticated it is and the more things you're going to need to include to actually win and get that summary judgment.
And also, in regards to the court, naming the CEO on the lawsuit in a small claims case is going to provide you with a lot of leverage, because in most states, people cannot be represented by an attorney. They can have an attorney, but they can't have an attorney represent them on their behalf in small claims. So, like, let's say you go and you sue, Equifax for jacking your credit. Well, name the CEO of Equifax on your report, and that's going to give you leverage, because that's going to require him to come to court as well, because he can't just send an attorney on his behalf, right? Because that's what, I think something like 47 out of the 50 states did not allow attorneys in small claims. So that's an advantage of small claims, and then a way that you can work that to your advantage. Does that make sense?
Yeah, good. Thank you.
So say if this is a mortgage that's way beyond the scope of small claims, because small claims is for what, $10,000 and under?
Yeah.
Where would you go for that?
Well, actually, I mean, the thing
County
is,
court should
you're
still
not
have to take it to
claiming
work,
money
right?
and
Yeah, we're
Well,
not claiming money. It's like
Yeah.
done. It's summary judgment. We don't
Yeah.
claim any kind of monetary relief here.
Well,
Yeah.
and if we set the terms of the new contract, and then, they acquiesce to the new contract, so then that is the terms of the new contract, and then they breach those terms that you've set, then now you can sue in small claims for a monetary amount for breach of contract. And then that's where you can go and get your summary judgment on that matter, and then get your writ of execution, where the judge will enforce the new contract.
See, okay.
So even if it's a $500,000 house, you just sue them for $3,000 for breach of contract, and then use the writ of execution to enforce your remedy.
Yeah.
So that would be
Awesome.
both, like breach of contract and summary judgment, same way, same time.
Well, the claim is a breach of judgment, because by them not responding to you through the administrative process, they've now acquiesced and agreed to those new terms of the contract. And if they don't meet those new terms, if they don't set off the account, if they don't send you the title, that's now a breach of contract. in
Oh,
court.
got it.
Yeah.
Yeah.
And
Thank you.
we're the 3K is for that breach.
Yeah, thank you. Got it.
You're welcome.
Hey, can I just interject on one thing on the small claims? I know a guy that, because it's a debt currency, it's not above a certain limit of lawful money. And so he was able to get like $300,000 claim of debt currency in there because it wasn't above $10,000. And he actually went to a lawsuit over his mortgage in Delaware over that. So I don't know, just something to think about.
Yeah, nice.
Yeah. Cool. Does anyone have like, we'll obviously do any question at the end, but for right now, this process specifically to get remedy. Does anyone have questions on getting remedy for discharging debt? The mailings, how we're gonna do it?
Well, the mailings are very clear. However, I have like problems like for what should be submitted to the court.
So obviously that's going to be on a case-by-case situation on what you're going to have to do there. I'd say for any type of unsecured debt, all you need to do is record the evidence in the county if it's unsecured. If it's secured, it may take more work, it may not. It depends on the situation.
By unsecured, Josh, do you mean like if you have a lien on it?
Yeah.
Or
Yeah.
not? Okay.
Yeah. But for the SBA, we did have a lien on a house and a car. It was, I'm sure, I think anything over 100K, you have to give up collateral. But with the SBA, they just released it. Like we didn't have to fight that. So if you do have to fight that, that's when you go for the summary judgment in court too.
So in order to tell if you have a securitized asset or debt, you would go for a certified UCC 11 state by the state, right?
I've never done one of those. I thought that just shows if you have a lien against you or not. I'm not too familiar.
Yeah, I've been led to believe that actually shows if you have any liens in your name for any type of property, like say a car or a mortgage loan or something. I typically see those on agricultural things, but nothing else. So if the company actually did file a UCC 11 then that means they truly do have a lien. Otherwise, if it's not there, then they don't have a lien on whatever it is that you have a loan on.
For sure. I'd say most companies don't know how to perfect a lien either, perfect title. So usually they don't hold up anyway. But yeah, that's why like I love just watching like banking videos, like how to perfect a lien, the Securities Act of 1933. Like just start like if you just start learning banking, things will start clicking with everything. Because that's what it's everything's controlled from the money. Top down. The money controls everything else.
Josh, from experience, I can say you're giving them, y'all don't get distracted with all the other, you know what I'm saying? Like you came here so that he could show you what he did. What
Yeah,
he's
yeah.
giving, I
Thank you.
want to say, Josh, that is solid information. Like I say, my mentor, Carlton Weiss, who was his mentor, and everything that you're saying, I can 100% confirm with Carlton Weiss, what he told him to do. For me, I just get caught up mixing stuff. So I want to tell everybody, don't get caught up mixing stuff. Find something
Yeah.
solid that works and work it. It's a lot of theories out here. So, and
Yeah.
if you want to play with theories, that's fine. Play with it and figure it out. Even I'm listening to people that's asking him, well, who do I send it to? Well, how about just send it to everybody? Like not being funny.
Yeah.
You know what I'm saying? Like, yeah, we really got to think outside the box because I bet you they're not sitting around saying who should they send stuff to. I got a warrant out for my arrest right now. And they start that shit to an address in a state that I don't even live in.
Damn.
For my arrest. So they don't care. They're just sending shit wherever. So I think the same way that they think. They just want to show that it was sent off. So send it to the CFO, send it to the CEO, send it to the indentured trustee, send it to the agent. I mean, what will it hurt?
Yeah.
Sometimes we just got to get out there and do it and try it and get your own. You know what I'm saying? Because what he did 100%, you might have to tweak it for your situation. So just do it. And I mean, to cover your ass, to make sure you don't get in legal trouble, just whatever you do, right? Void where prohibited by law. That should get out of jail free card. I know that from somebody that's in jail. So whatever you do, void where prohibited by law, and just try things. You're a creator. We're all creators. So get to creating. That's all I want to say. Good job, Josh. But this is definitely solid information.
I
have
appreciate you, Lisa. Man, you're the best. Appreciate that.
Do you have any problems with clerks at the county filing that paperwork?
Yep. No, I've ran into that. The real way against that is I actually have a form. I don't know if I'll be able to find it right now. Arizona clerk recording. And basically and what you need to really do is go onto your local county website. I can't find it right now, but I can potentially send it to you, to all you guys after class. But what all you guys need to do is go to your local county website, look at the records, and anything that you see that's been recorded before can get recorded again. And anything that's been recorded in one county can be recorded in another county, full faith and credit. So if they're denying you, let me potentially know. Also, the format is key. You need a cover letter. You need a spot for the clerk. Like you can't just give them a piece of paper and say, record this. Like there has to be a cover letter. There has to be like a spot for them to put a stamp. Usually they're going to send it somewhere once it's recorded. So you need to have an address here for a spot for the notice to be sent to upon recording. It could be for many reasons. Definitely message me if you're getting stuck. But yeah, try those few things that I just mentioned.
Josh, let me say something on that too. I'm a notary.
Yeah,
And so
go ahead. Nice.
Call the clerk and ask them, what are their requirements? If it's a cover letter, they're going to tell you. They're going to email it to you. If they don't record it, ask for their superior. If they don't do it, ask for their superior. If they don't do it, ask what clerk here holds a bond so that I can make a claim. And I promise you, your shit's going to get recorded.
Yo, all that was fire. Everyone take notes, watch the recording, and write all that down. That was fire. Thank you, Lisa.
Just real quick, now that class is virtually over, I've sat through some other people's, Zoom classes and stuff. I just discovered that there's actually a way to do transcription with Zoom. Do you have your transcription on or no?
Oh, shoot. I hope I can go back and do that, but I'm pretty sure it's like some AI bot like a note taker bot.
Yeah, you know, I did. I've sat in on meetings. I tried to kind of figure out how to do it once with my sister, and it looks like there's a way to actually turn transcription on, and the transcription will not be fantastic. But for those of us who actually go through and spend a million years trying to hear everything, the transcription would be really useful. And then you know, you got to kind of go in and edit it, but it saves a lot of time. So in the future, turn the transcription on when you start your meeting.
100%. I'll keep that in mind, Julie. I appreciate that because you're right.
Okay, I can give you advice. If you upload this video to the YouTube, there is an option there to do transcription. It's really useful.
Wonderful.
Line by line.
Man, this community is already awesome. I appreciate you guys. But yeah, I have, like I said, if you stay till the end, you're going to get the recording, all the templates. And last thing is really the goal to all this. Like I mentioned earlier, the goal is to get your personal credit report beefy, build it up, make it nice. And then you want to open businesses, whether that be a trust, an LLC, a corporation, really anything where you can then use that good credit on your personal side, leverage it as a PG, a personal guarantor, to really back any transaction that you want through your business. And really you can get anything through credit, and then you can discharge it through a business, no problem, rinse and repeat. I know Donald Trump, he's been bankrupt 6 times. He's a multi-billionaire. It's because he does this. This is what he does. He uses other people's money to start businesses. He gets in a ton of debt. He doesn't pay it back. He files bankruptcy. He's not liable because he's not attached. It's a business. So when you hear Donald Trump's been bankrupt, yet he's still a billionaire, it makes you think a little bit, where we can start using trusts. And I like to just study the biggest players. Like, that's why I mentioned Trump. I see like Nike literally didn't pay any money in taxes. Like, how do you make $1 billion and not pay taxes? Like, it's a game. It's all a game. So we're just going to work together and really figure it out. But this is a nugget right here where you really just need to build your personal score to then discharge stuff on the business side. And that being said, for all you guys stay until the end here, I want to give you guys the templates and the recording, 100% free of charge. Means a lot. Obviously, I want to help you guys get remedy. I am going to offer the first person to prove to me that they were able to discharge debt. I'm sending $500. So first person to go through this process and actually, and like I said, I'll answer questions and help you guys. But first person to actually do this, I'm going to send you guys $500, and we're going to work together probably most likely in depth, because it's a long game, guys. It's a long game, and we need to work together. And my entire life's mission has been to kind of take down this banking system, the powers that be, the people who are controlling everything, by spreading wisdom, spreading the knowledge, and working together, building real abundance on earth, because earth is abundant. There's no scarcity. You plant a little seed. It just takes a little bit of work, but God is good. It produces an abundance, and we just need to work together to help each other out and produce more of that abundance, not take away. Because the more I have, if I have 10, like, let's say I have 10 sky rises right here, downtown Miami. I own 10 of them. I built them. That's 10 more places for anyone to live. Same with all of you guys, right? Like, if all of us had 10 sky rises, like, we all have 10 to ourselves, right? So that's the goal. And that's why I am opening up a Discord. Anyone that stayed to the end is invited. You're invited to our private Discord. It's going to be a study group, daily support. I'm in there every day answering questions, helping people get remedy. All of our templates, not just tonight, but we're going to send you guys trust templates, foreign EIN templates, any type of credit repair, small claims court to win a claim up to 15K. I think that's in Georgia. Obviously, injunctions are huge on public officials. Protect your family, travel free. Stone also has a passive income opportunity where I think, Stone, you're making like 20% a month on your money.
Yeah.
Not really doing anything.
20.5% per month. If anybody's interested in that.
You can kind of pull that up after if anyone is interested, but anyone that wants to join our private group, we're going to fund your business $150K per LLC and handhold you through the discharge process. And like I mentioned, that passive income opportunity, me and Stone both personally have money in there now for multiple months, and we're making it over 20% a month doing nothing. And the fact that we can fund businesses up to 150K, put some of the money in there and be making 20% a month off that. That's what we want to help you guys do, because this is, like I said, a long game, and the people we're going against, it's not going to be easy. So we want to work together, and message me if you're interested in that. Like I said, if you're on the call now and you hear my voice now, we'll get you guys up to 150K per LLC, and really just give you all our templates like we said. But if you stay to the end, message me the word remedy. Message me remedy so I know you stayed to the end. So I'll send you everything for free, the recording and the templates for free here. Messenger. Because they were literally, and I know this was a smaller class too. I like I said, apologize about the link. We'll be holding another class next week probably. You guys are welcome to join again. But nice, yeah, I'm getting you guys' messages. And if you want to join the study,
connect on the socials too.
Yeah, connect on socials, guys. We're all trying to help each other win. That's really what it is. The more you guys know, the more we know. The more we know, the more you guys know.
Josh, how about this? And I'll help you out once I get the recording. Everybody drop your emails in the group chat, and I'll put together one email for you, Josh, with everybody CC.
Oh, cool. Yeah.
As well, so that you can so that then everybody can respond to that and put like their Facebook links. You see what I'm saying? So then everybody can just go follow, the Facebook or how you want to connect. So it'll be one email, and if you just reply all, everybody will get the message. I drop emails, and when I get the recording, the chat part of it, I'll go on the chat and I'll do that for you, Josh.
I appreciate that. And yeah, everyone drop your socials, drop your email. I probably won't be dropping my phone number, but
Josh, the email is cool. The email is cool because I don't want you getting overwhelmed. You remind me of me.
Yeah.
So I'm feeling your energy. I don't want you to get overwhelmed because I definitely got overwhelmed. And
no,
I
mean,
now.
Lisa, you're 100% right. Even like right before the class, when the invitation wasn't going out, I was like, dang, overwhelmed, like 300, but we're here to help all you guys out. If you want to join the study group, message me study and you'll have lifetime access. It's not, we do have a one-time fee. It's not a lot. We do understand everyone's in different situations. We don't necessarily need money ourselves. It's just for you to actually show up, get results. Because we need, like I said, unless you actually take action here, nothing will happen. So.
Hey, Josh, have you ever thought about starting your own Facebook group? So some of this information we could easily share instead of through Messenger.
For sure. Yo, that 1099A group banned me. They're haters.
Really?
I'm trying to help people. Like, this is what I did. Like, and yeah, someone banned me. Damn. So yeah, I need my own group. Because like, I just post trying to give information. Like, I literally post sauce and they either don't accept my post. It gets posted, it gets taken down. Right.
I got you. I'm about to do it while we on the phone, and I'll drop the link. So
let's go. Yo, let's build. I definitely love the energy as well for all you guys speaking up. I appreciate it. And this is just a start, guys. Just a start. Message me on Facebook support or study. Message me study if you want the invite to Discord. And like I said, I'm on Discord every single day. We'll probably be holding like classes twice a week on different topics. And obviously all things that either I have done or someone else in the community has done. I don't know if any of you guys know King Chameleon. He is a master of getting land patents and discharging mortgages. Most likely going to have him on in the next couple of weeks, where he can show you guys what he did for his clients to get a land patent and discharge a house. Because like I said, I'm working with him right now to actually discharge my house. Once I do that, I'll be able to help you guys from my perspective. But yeah, we'll have speakers on. We'll be doing class probably like twice a week. And we'll be helping you guys with really just hand holding through whatever we've done or whatever someone else in the group has done. And if you can bring value to the group, you can run your own call potentially. But for this specifically, don't forget, guys, I'm sending 500 to the first person that gets remedy from this class. I'd appreciate testimonials if you guys get results. I'll help
Yeah,
you
click
guys.
that link. Click that link and join that group. Josh, once you join it, I'll put you as the owner. I'll give the ownership to you.
You're the best. Let me stop sharing.
Josh, I'm wondering, I have already did put the corporations into default, but they send the debt to debt collectors. I'm just wondering if I can pick up the process and send them notice of, STPL and or it would be wise to start over with some different company.
Huh. I don't know what you've done in total so far, so I'd probably use my process with either that same company or a new company, but start from the beginning.
Okay.
I'm unable to join the group.
Thank you.
Are you Joshua Newman on Facebook? Is that how we?
Yeah, Joshua Newmark.
1 second, yeah. Let me see what I do. Let me change some settings. Let me see. I did it super fast, so hold on. The group is okay. I'm gonna open it up for a minute to let y'all. Hold on. Who can join the group? Invite with link. Okay, so I gave y'all the invite. Let me see privacy. Hold on, y'all. Give me 1 second. I literally pulled over to make this. Boom. Admin, see all tools. Okay, so go ahead, Josh. You can talk. Give me 1 second, y'all.
Yeah, no, go ahead. You're good. I guess if anyone has any questions, feel free. Floor is open. I'll be responding to all you guys. We'll probably wrap up here in 5-10 minutes once we all get into the group here. Yeah, no, Lisa, we really appreciate you. I appreciate everyone on this call.
Hey, brother, I had a question. Back to the reacquisition of
Yeah.
the securities. You're asking for reacquisition, but they never give them. So then they provide just the remedy of discharge.
Yeah.
But there's no recoupment from the securities, right? They don't ever give that to you.
That's something I've never been able to do. I'm trying to crack that though. I'm trying to recoup those funds. So once I crack it, I'll bring it to you guys, but
I'm working on it for my wife's Audi from Bridgecrest. I tracked down the asset number in the security in the trust. And so I'm gonna move for a partial liquidation of the trust. But if it works, I'll let you guys know.
100%.
Yeah, keep us updated for
Yeah.
sure.
I got one.
Yeah, go ahead.
Peace and love, everybody. So, me and my wife have an issue with one of the finest credit acceptance, and we're actually on a way of sending a fourth notice to them. Actually, it's going to be a couple of things. One of them is in reference to sending a cease and desist a cease and desist letter directly to their quote unquote legal department, in which the names that were that the documents were specifically for or addressed to were the CFO, CEO, and the indenture trustee. With that